Constitution of India provides to every citizen various fundamental rights as well as the remedies for violation or infringement of those fundamental rights. We know that Article 32 and 226 of Constitution of India provides the availability of remedies for infringement of the fundamental rights. So, it appears that if any fundamental right of any citizen is being violated, then he can avail the scope as a remedy either by virtue of invoking Article 32 of Constitution or Article 226 of the Constitution. Then the question may arise that what is the difference between the scope of Article 226 and 32 of Constitution? The topic of discussion is very vast, so that's why I will discuss this matter in a fragmented manner. In this first episode, I will discuss it in a brief manner. Later on in other episodes, I will discuss this topic in detail. Friends, we are aware that Part 3 of Constitution of India deals with the fundamental rights. Article 12 to Article 35 is covered by Part 3 of Indian Constitution, that is fundamental right. And we are aware that Article 32, which is included in Part 3, it provides the remedies for violation of the fundamental right. So in pursuance of Article 32 of Constitution of India, for violation of the fundamental right, any person can file application before our apex court, that is Honorable Supreme Court. So Supreme Court is entitled to interfere for violation of the fundamental right if any person, aggrieved person, invoked by Article 32 of Constitution of India. Similar power is given to various high courts under Article 226 of Constitution of India. So in case of violation of fundamental right, any person can move besides Supreme Court to High Court of particular state. Then the question arises then, what is the difference between the scope or ambit of Article 32 and 226 of Constitution of India? So let us have a look that Article 32, it deals with the power of Supreme Court for interfering in case of violation of the fundamental right. And similarly, Article 226, it is the power of high courts of various states for interference in case of violation of the fundamental right. Now question is, what is the difference? That means a comparison between the scope of Article 32 and 226 of Constitution of India, that is the topic of discussion now. The first point of difference of ambit or scope of Article 32 or 226 of Constitution of India is that Article 32 can be invoked only in case of violation of fundamental right. That means if the fundamental right as enshrined in Chapter 3 of Constitution of India, that is between Article 12 and 35, if any fundamental right is being violated, then only any person can invoke or seek the remedy under Article 32 of Constitution of India. But in case of violation or infringement of non-fundamental right or other ordinary legal right, Article 32 cannot help. That means Article 32 cannot be invoked in case of violation of non-fundamental right or other ordinary legal right. But scope of Article 226 is much more wide in this context. That means Article 226 can be invoked in case of fundamental right violation as well as for violation of non-fundamental right or other ordinary legal right, because it is categorically stated in Article 32 that proceedings can be drawn only in case of violation of the fundamental rights. But Article 226 is not confined within the violation of 220 means fundamental rights only. Rather, its ambit reaches far beyond that. That means in case of it is written in Article 226 that proceedings can be drawn for violation of the fundamental right or for any other purpose. So as the word any other purpose is inserted in Article 226, it enlarges the scope of Article 226. So first point of distinction, that is for violation of fundamental right only, that is the scope of Article 32, whereas in case of 226 for violation of fundamental rights or for any other purpose. Now I am coming to the second point of this distinction. Second important distinction is this: the ambit or scope of Article 32 in case of application, it is much more wider than Article 226, because 32 can be invoked for infringement of fundamental right throughout the entire territory of India. So anywhere in any state, if the fundamental right is violated of any citizen, he can seek the remedy by invoking Article 32 of Constitution of India. Whereas in case of Article 226, its limitation is confined within the ambit of a particular state. So if any citizen's right is violated, if he wants to avail the scope of Article 226, then he is to file that application before the High Court of the concerned state where his fundamental right is violated. So if any person who is residing in Calcutta, if his fundamental right is violated, then he can seek the remedy only by applying before Calcutta High Court. But he cannot apply it before Bombay High Court or any other concerned state High Court, because so far Article 226 is concerned, its territorial jurisdiction is confined to the particular state only. So that is the difference, that in case of Article 32, jurisdiction extends to the entire territory of India, whereas in case of Article 226, jurisdiction extends to the territory of a particular state. Now I am coming to the third essential distinction. The third essential difference is this: Article 32 can be invoked when the infringement of fundamental right is made by state or authority of the state. That means Article 32 can give the remedy in case the fundamental right is violated by state. That means when state is responsible for violation of the fundamental right of any citizen, only in that case Article 32 can be invoked. But if fundamental right is being violated not by state but by other person, then only 226 can be availed. That means Article 226 power is much more wider in this sense from Article 32 power of Supreme Court, because by virtue of Article 226, order can be given not only against the state but any other person. So in case of violation of the fundamental right or any other ordinary legal right of any citizen of India, he can move before High Court of the concerned state, because Article 226 empowers High Court to give the direction, including writs of various nature, not only against the state but also against other person. So that's why it is the third ingredient, that power can be exercised only against the state by the scope of Article 32, whereas in case of Article 226, power can be exercised against state and any other person. As such, if any person is unlawfully detained by police or by any government authority, he can file writ either before Supreme Court under Article 32 or before High Court under Article 226. But if that person is detained by any private person, then he cannot invoke Article 32 of Constitution, because Supreme Court has power to give direction by virtue of Article 32 only against the state, so not against the private person. But in case of High Court, if any person is detained by any private person unlawfully, then he can invoke Article 226. High Court has power to issue direction in such case against the wrongful confinement, and direction can be given against the private person also. So in comparison with that, so ambit of Article 226 and its application is much more wider than Article 226 in this regard. And I am citing one of the case, that Ikram Hussain Ahmed case. It was decided by the Apex Court that if private person is unlawfully detaining somebody, then Article 226 can be invoked. So Ikram Hussain Muhammad versus State of UP, Supreme Court stated that Article 226 can be invoked in case of detaining by any private person. Now a question may arise in our mind that whether we can directly come before Article 32 of Constitution before Supreme Court of India, or prior to that we have to apply before High Court under Article 226. That means whether for violation of the fundamental right as a remedy, whether we can avail the scope of Article 32 by directly filing the petition before Honorable Supreme Court, or before going to Supreme Court we must have to file before High Court, and then only we can move before Supreme Court. Now various judgments are there regarding its favor or against it. So I am citing one judgment, that is Ramesh Thapar versus State of Madras, where our Apex Court stated that it is not necessary for invoking Article 32 of Constitution that beforehand we have to apply before High Court by Article 226, then we have to come before Supreme Court by invoking Article 32. We can directly apply for violation of the fundamental right in pursuance of Article 32. That means any person for violation of his fundamental right can seek the relief by invoking Article 32 of Constitution. But in another judgment, Supreme Court stated that it is always preferable that for violation of fundamental right, the person concerned must seek the relief by moving an application under Article 226 of Constitution before any High Court, then only the question of Supreme Court comes. That means at the first instance, he should not come before Supreme Court. So that was decided in Kanubhai Brahmat versus State of Gujarat. So in Ramesh Thapar versus State of Madras, it was stated by Supreme Court that any person for violation of the fundamental rights can move directly before Supreme Court by invoking Article 32, whereas the changed version made by our Honorable Supreme Court in Kanubhai Brahmat versus State of Gujarat, that it is always means necessary that at the first instance the concerned party for violation of the fundamental right must seek relief by invoking Article 226. So hereby it can be concluded that Article 32 and 226 is giving the vast scope to citizen for violation of the fundamental right. So in other episodes I will further discuss in detail about other aspects of application of Article 32 and 226.